So I have an important update in the Vanderstock frames and receivers case. The ATF is now asking for Supreme Court review, and the battle is now happening at the highest court in our nation. So let's talk about what is happening. But real quick before we jump into this video, I want to ask you all for a huge favor. About 60% of all my viewers here on YouTube are not actually subscribed to the channel. So if you enjoy this type of two-way content and you want to make it, get to more people, please consider subscribing to the channel. That really does help this channel to grow and for this information to reach more people. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be discussing an important development in the ATF frames and receivers case called Vanderstock v. Garland. The ATF has filed for Supreme Court review in the frames and receivers case. The Pro 2A side, FBC, SAF, and others involved in this case have responded and said, yes, the Supreme Court should take review of this case immediately, and ultimately that the Supreme Court should rule that the Fifth Circuit and the lower court actually got this right and that the ATF rule is invalid and must be struck down. This critical review is happening because the Fifth Circuit recently handed down its decision on the summary and final judgment of this case. A Fifth Circuit panel recently decided and partially upheld a lower court ruling, but also vacated it partially because the Fifth Circuit believed a vacatur of the entire rule nationwide was beyond what the lower court could do. Because of that recent three-judge panel in the Fifth Circuit, the ATF only had a few options. They could either file for en banc review in the Fifth Circuit, or they could bypass that review and seek Supreme Court consideration. They could file for Supreme Court cert. I predicted, looking at some of the lower court filings, that the ATF had decided to take this case up immediately to the Supreme Court for a merits review, and that's exactly what they did. Based on the procedural posture in the lower court decision in this case, I think the Supreme Court is actually going to be forced to have to take review of this case, or at least GVR it after the Cargill decision, which we've covered. That was the case dealing with the ATF's restriction on bump stocks, treating them as actual machine guns. And that case had oral arguments just a couple weeks back. And so that's also going to be critical for what now happens and develops in this Vanderstock case. The ATF is hoping that the recent 5-4 emergency stay order that the Supreme Court issued prior in this case in the ATF's favor will lead to a favorable decision on the merits of this case. But in my opinion, that's a huge mistake for the ATF to believe that. Now, to understand what is at stake in this case and why the Supreme Court's hands will be forced to take this case up, we have to talk about what has happened prior in this lawsuit. Originally in this case, the original plaintiffs, FBC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule against unfinished frames and receivers. On review, lower court Judge Reed O'Connor granted a limited preliminary injunction against the ATF, which ultimately prevented the ATF from enforcing the rule against the individual plaintiffs in this case and the companies themselves, which was Tactical Machining, and then also its customers. Looking at the ATF's rule on frames and receivers, Judge O'Connor found that it's facially invalid under the plain text of the GCA and that Congress did not grant the ATF authority to regulate these types of items. Now, after that, other companies like Black Hawk Manufacturing Group, which is also known as 80% Arms, Defense Distributed, and other companies sought to intervene in this case as named plaintiffs. They also asked for Judge O'Connor to grant the same limited protections which were granted to Tactical Machining, another company that deals with unfinished frames and receivers. Ultimately, the court there, Judge O'Connor, did grant the protections to those new companies and also their customers. Now, after the preliminary injunction stage, the plaintiffs then sought to win the entire case by asking for a motion for summary judgment. And in response, Judge O'Connor did grant the motion for summary judgment. And the relief he granted was vacating the frames and receivers rule in its entirety nationwide. So it was a nationwide vacatur of the ATF's frames and receivers rule. Of course, the ATF did not like that, so they filed an appeal up to the Fifth Circuit. While the ATF was appealing that to the Fifth Circuit, they also sought an emergency stay order from the Fifth Circuit so that ultimately they could still enforce the rule while the appeal was taking place. However, both Judge O'Connor and also the Fifth Circuit three-judge panel denied that emergency stay request. That then led the ATF to go directly up to the Supreme Court on an emergency basis, on an interlocutory emergency basis, and that was kind of the first time that they did that in this case. They asked for the Supreme Court to issue an emergency stay order, which ultimately would prevent the nationwide vacatur issued by Judge O'Connor from going into full effect. And ultimately, what the Supreme Court did, in a 5-4 decision, a 5-4 order, the Supreme Court agreed to stay the enforcement of the summary judgment decision, which vacated the rule nationwide. In that 5-4 stay order, Justice Barrett and then also Justice Roberts joined the liberals to grant the stay order in favor of the ATF. So Justice Barrett and Roberts sided with the ATF, and the ATF got their emergency stay order. Now, after the Supreme Court issued that 5-4 emergency stay order, 80% Arms and then also another company, Defense Distributed, went back down to the lowest court, which was Judge O'Connor in the district court, and they asked for Judge O'Connor to issue an emergency motion and a new preliminary injunction. They asked for Judge O'Connor to put back in place his prior preliminary injunction that protected just the company and their customers. Essentially, they argued that the Supreme Court's emergency order and the emergency stay that they granted only prevented the nationwide vacatur from being forced, but ultimately Judge O'Connor could grant a more limited protection, a more limited injunction, which he had already issued in this case. On review, Judge O'Connor agreed and granted the injunction to protect the companies and their customers once again. Again, the ATF did not like that, so they filed an appeal back up the Fifth Circuit, arguing that Judge O'Connor directly defied what the Supreme Court said in that 5-4 emergency stay order. They argued that Judge O'Connor was circumventing what the Supreme Court had said. The Fifth Circuit disagreed with the ATF and said that Judge O'Connor could issue this new limited injunction, this new preliminary injunction, which was simply identical to what was in place prior. And again, since the ATF lost at the lower court level and also at the Fifth Circuit level, they decided to file a new emergency application, a second emergency application to the Supreme Court, asking for the Supreme Court once again to vacate that new limited injunction. And for the second time, the Supreme Court intervened, stepped in, and sided with the ATF and struck down that limited preliminary injunction. And because of that, the Supreme Court ultimately prevented any positive relief in this case while the summary judgment was being reviewed by the Fifth Circuit on appeal, and really no new relief or any type of positive relief could be issued even by the Fifth Circuit once they reviewed and decided this case. The Fifth Circuit recently did decide the merits of this case, and in their decision, the panel partially upheld the lower court's decision, which struck down that ATF rule. What they did also do partially in their decision and said that Judge O'Connor could not grant a nationwide vacatur of the rule, and ultimately that was kind of because of what the Supreme Court said in their emergency orders. I predicted that I thought the ATF would take this case immediately back up to the Supreme Court, and that's exactly what they did. FBC and the plaintiffs have now filed their response in the Supreme Court petition, and they agree that the Supreme Court should grant review to this case immediately. The organization state in the response that respondents agree with the government on the proper disposition of the government's petition for a writ of certiorari. This court should grant the government's petition to determine, once and for all, whether ATF's rule expanding the definition of firearm to include weapon parts kits and items that with additional manufacturing could become frames and receivers is consistent with the definition of firearm in the Gun Control Act of 1968. The organizations go on to state that the definition of firearm under federal law is an important issue that was precisely addressed by Congress in the Gun Control Act of 1968. If that definition has become obsolete or unsatisfactory in any way, that is an issue for Congress to address. The Fifth Circuit properly held that the ATF overreached by effectively attempting to amend the statute itself. The court should grant certiorari and affirm. So SAF and FBC and the other companies involved in this lawsuit, like 80% Arms, Tactical Machining, Defense Distributed, and all those others, are agreeing that the Supreme Court should take review of this case right now and deal with what the ATF is doing. However, the Supreme Court should ultimately affirm what Judge O'Connor ruled and what the Fifth Circuit 3-judge panel ruled, striking down this rule and saying that it was beyond the ATF's authority. The 2A orgs go on to argue in their response that even though there is not a broad circuit split right now dealing with this whole ATF rule, the Supreme Court should still grant review in this case right here. And traditionally, the Supreme Court really likes circuit splits and controversy between circuit courts. Like if you had the Ninth Circuit and then the Fifth Circuit saying different things, the Supreme Court usually likes to take review of those cases. But this still is a final merits review. It is still something coming out of the Fifth Circuit. And ultimately, the Supreme Court does not grant review in this case, then that means that the Fifth Circuit 3-judge panel's decision would sit as proper. And ultimately, I think something like that is going to force the Supreme Court's hand, at least for them to GVR this case, even after their decision in Cargill. Now, I don't have a ton of confidence in the Cargill decision if you listen to those oral arguments, or you can listen to my breakdown after those oral arguments in Cargill, which deals with the ATF's overreach in regards to bump stocks, a similar expansion of language in the GCA and the NFA to wrap in items like bump stocks into the definition of machine gun, similar expansion of language beyond the ATF's authority, but it seemed like maybe some of these Supreme Court justices that we wanted to be on our side may not be on our side. So it's going to be interesting to see maybe how that plays out, how Cargill will affect Vanderstock, if they have an interest in taking Vanderstock after Cargill or while they're trying to decide Cargill, or maybe just Vanderstock will be granted, vacated, and remanded after Cargill. So major developments in this case. It's going to be interesting to see how this plays out. This is an important case that we'll be watching closely, and if anything changes, I will let you know. So if you liked this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and don't forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.